Hello everyone, Jai Hind and welcome to the platform of SRIRAM's IAS, and in today's session we'll be discussing about the right to freedom. We have already discussed about right to equality, and in today's Polity in 20 minutes we'll be covering the concept of right to freedom that has been given in our constitution. But before moving ahead, let me tell you that we are offering you with free 1:1 mentorship. Alright, what you have to do over here is that if you have any doubts, you need any clarification regarding the UPSC examination, Civil Services Examination, you just need to fill out the form that is given in the description box, as well as it has been pinned in the comments as well. Now, when we talk about the right to freedom, so right to freedom is again a fundamental right given under Part 3 of the Constitution, and the Part 3, they cover the articles from Article 12 to 35. But we are talking about right to freedom. The right to freedom have been enshrined under Articles 19 to 22. And over here, the main or major motive for providing with the right to freedom was to ensure the liberty, that is freedom, and also protection and human dignity for all the citizens. Because as had been rightly said by Moshe Dayan, freedom is the oxygen of the soul. Alright, now what was the historical evolution for the right to freedom? So we all know that during the British era, the British Raj, what happened was that there was a suppression of the civil liberties and fundamental freedom under the British Raj or the colonial rule. However, later on, when the Constituent Assembly was formed, there were severe debates upon granting the freedom, and those debates were basically pioneered by Dr. B.R. Ambedkar, Jawaharlal Nehru, as well as K.M. Munshi, and that have shaped the various freedoms that have been granted into our constitution. Now, when we come to the Western constitutional influences that have been taken into consideration, whether we are talking about the US Bill of Rights or even French Declaration of Rights of Men, they have been taken into consideration while formulating the right to freedom for the Indian citizens, as well as when we are talking about the constitutional objective. So there had been a delicate balance or the right balance that had been created between individual freedom and the social order for the nation building. So that was the historical evolution for granting these different right to freedoms which have been enshrined into our Part 3 of the Constitution. Now, the first article is Article 19, which provides with 6 fundamental freedoms. Initially, there were 7, but later on, they were, after the 44th Amendment, one of the freedom was taken away, and now we have the 6 freedoms which are there. We have Article 19(1)(a) that provides for freedom of speech and expression. Alright, there is freedom or right to assemble peacefully and without arms under Article 19(1)(b). There is freedom or the right to form association or unions that has been granted under Article 19(1)(c), right to move freely throughout the territory of India under Article 19(1)(d), and the right to reside and to settle down in any part or territory of India under Article 19(1)(e), and we have the 6th right, that is right to practice any profession, occupation or trade that has been granted under Article 19(1)(g). So these are the 6 fundamental rights. But however, when we talk about the fundamental rights, I told you that no fundamental right except from Article 17 are the absolute rights. So there are certain reasonable restrictions which have been implemented. Alright, so now when we talk about the over here, so we have the grounds for restriction of these rights on the basis of sovereignty and integrity of the nation, on the basis of security of the state, public order or morality, and contempt of the court, defamation and incitement to an offense. Over here, there had been a landmark example, that is Shreya Singhal versus Union of India in 2015, where Supreme Court had struck down Section 66A of IT Act or the Information Technology Act for being unconstitutionally vague and violating the free speech. So that was in Shreya Singhal case in 2017. And there are certain judicial doctrines also that have been propounded. Like for example, in Keshwananda Bharati case, there was doctrine of reasonableness, and in the modern Supreme Court application, test of proportionality had been propounded for the right to freedom. Alright. Now, when we talk about the right to freedom, the first and the foremost important right to freedom that has been enshrined into Article 19 is the freedom of speech. Now, it says, when we talk about the over here, The freedom in the Indian constitutional jurisprudence, it has been the most debated and also most litigated freedom when it comes to the freedom of speech and expression. All right, over here, there has to be a kind of balance between the free speech as well as hate speech. Now, there are certain contemporary challenges as we are moving ahead in a digital era. All right, there are OTT platform regulation and online expression controls. All right, there is sedition debate, that is section 124A of the IPC, that is under constitutional review, as well as balancing national security with the individual liberty is a matter of concern when it comes to the freedom of speech. And over here, when it comes to the Menka Gandhi versus Union of India case, in 1978, the Supreme Court said over there that the liberty as well as the procedure that is established by law have to be taken into consideration when we are talking about the freedom of speech. Now, there is also another right, that is right to assemble and also right to form associations. Right to assemble anywhere and peacefully without arms has been granted. Now, over here, when we talk about right to assemble or right to form association, that is important in any democracy. Because when we are talking about democracy, this is important for or essential for protest, for the civil societies, as well as collective expression in a democratic setup or governance. However, there are certain reasonable restrictions that are there. All right. Now, when we are talking about right to association or right to form, right to assemble, that have been limited by consideration of public order, morality, and also sovereignty. All right. So these rights can be taken away if they are against public order, morality, or sovereignty. And when we are talking about the constitutional tension, there had been a constitutional tension between national security and freedom under Article 19(1)(c), and that leads to certain organizational bans that you must have seen. Various terrorist organizations have been banned, and even those organizations which are basically against the threat of the security as well as integrity of the nation had been banned, and that is because of this particular reasonable restriction that is there. Now, over here, there had been Ramlila Maidan incident in 2012 where Supreme Court held that the fundamental right to peaceful protest and assembly is a key part or key fundamental right that has been granted by the Constitution of India. Now, there are other freedom, the freedom of movement, residence, as well as profession that had been granted. When we talk about movement and residence, this is vital for national integration, economic opportunity, as well as federal unity across different states. However, there are certain constitutional exceptions. All right, when it comes to the right of residence or movement, so certain areas have been protected which are tribal regions. All right, so when we are talking about the tribal areas, they have been protected, the strategic border zone have been protected, and there had been restrictions in the public interest that have been placed. All right, so that is, or they are the constitutional exception. And when it comes to the professional freedom, so there is complete economic liberty for the livelihood, and the livelihood protection has been granted when it comes to the right to freedom of profession. And when it comes to a case that was there in the Supreme Court in 1989, Sudan Singh versus NDMC, over here it was recognized that street vending is a legitimate profession under the article or under the freedom of profession. All right, under Article 19. The next article is Article 20 that provides for protection against conviction. All right, it is a kind of safeguard that has been provided in the criminal justice system, and over here there are three freedoms or three rights which have been provided. The first one is no ex post facto laws. That means in the criminal justice, not in the civil justice or civil jurisprudence, but in the criminal justice system or criminal jurisprudence, what will happen is that there would be no retrospective legislation that would be applied. Now, what it means? It means that if a law will be institutionalized today, it will enter into the force today. It cannot have a retrospective impact, or it cannot be applied from a previous date. So that is, there would be no ex post facto law. Then the another is that there would be no double jeopardy. That is, a person cannot be prosecuted twice for the same offense that he has committed. And then also there would be no self-incrimination, where a person will not be compelled to be a witness against himself. So these three rights are basically given, where these protections, they align with the international human rights standards and as well as criminal jurisprudence principles. And there was a foundational case where MP Sharma versus Satish Chandra in 1954, where the scope of protection against self-incrimination had been established by the Supreme Court. Alright, the next article is Article 21, which is one of the most important right when it comes to the right to freedom. Alright, it is protection of life as well as personal liberty. Now, when we talk about over here protection of life and personal liberty, so it provides that life does not means mere animal existence, but also the dignified human existence that should be there. Alright, so over here, this is one of the right which have been, the scope had been widened by the Supreme Court tremendously, and over here various rights have been inferred to the right to protection of life and personal liberty, like for example, right to education, clean environment, health care, as well as dignified life and right to privacy. Alright, there were certain transformative or landmark judgments where Menka Gandhi case in 1978 was there, which have revolutionized the liberty interpretation or the interpretation of freedom in the Constitution, and Puttaswamy case in 2017 where privacy was granted as a fundamental right. Alright, now next comes Article 21A, that is right to education. Now over here, this was added by a constitutional amendment, and the amendment was 86th Amendment in 2002, which provides for free and compulsory education for children that are between ages of 6 to 14 years. That means the primary education is to be provided free and compulsory education has to be provided, and over here it fulfills the directive principle that is provided under Article 45. Now over here, this had been implemented through a law, that is the Right of Children to Free and Compulsory Education Act in 2009. So the act, the Constitutional Amendment Act, was passed in 2002, but then it took 7 years to pass a legal framework that will secure the right to free and compulsory education for the children that are aged between 6 to 14 years, and it transformed education from a directive principle to a justiciable right for these children who are between 6 to 14 years. The next comes the Article 22, that is protection in cases of arrest, alright, or in detention, where a person had been detained. Over here, there are three rights which have been provided, but let me tell you over here that there are two types of detentions which are done. One is punitive and the another one is preventive. When it comes to punitive detention is when an act or offense has already been done. Alright, so afterwards, after offense has been created or offense has been done, so afterwards, if a person has been detained, so he's that is called as punitive detention. But preventive detention is when an act or offense is yet to be done. Like for example, a terrorist is planning attack somewhere. So he is planning something. So we will not wait until the attack happens. So we will nab him, and that is called as preventive detention. So these rights are under the punitive detention. What are these three rights which have been provided? There is right to information, where a person has to be informed of the grounds on which he or she has been arrested. Alright, there is a right to legal counsel, where a person is entitled to consult and be advised and defended by a legal practitioner of his or her choice. And then there is a magistrate presentation, where a person have to be produced before the magistrate under or within 24 hours of the arrest. However, this over here, it is beyond period of transportation. Alright, beyond period of transportation. Like for example, let me give you an example why I'm saying beyond period of transportation. A person had been arrested from Kerala. Now he is coming to UP. So it will take about 3 days in transportation or while commuting from Kerala to Uttar Pradesh by or via railway. Alright, so ultimately the 24 hours is beyond the transportation period, and when he is or she is being withheld in the jurisdiction of that particular region where the offense has been committed. So then afterwards there is a period of 24 hours within which he has to be produced in front of the magistrate. But these protections are in punitive cases. They are, again, let me tell you, these are again in the punitive cases, not in preventive cases. All these protections are provided only in punitive cases. In preventive detention, there had been exception. Over here, the detention could be extended up to 3 months. Up to 3 months without trial and extendable with specific laws or under specific laws. There is exception to normal procedure safeguards. Alright, there is, or it requires advisory board review as well, and there is constitutional but controversial provision that is of the preventive detention. But again, it is necessary for protection of the security and integrity of the nation. Over here, A.K. Gopalan versus State of Madras have relied upon the interpretation of Article 22 as well as ADM Jabalpur in 1976, where it was later overruled for the emergency excesses. Alright. So when we talk about the preventive detention, it is a constitutional debate, and when we talk about over here, we have right now a prominent Preventive Detention Act that is applied in whole of India. We have certain acts which are there, state specific act, alright, like we have Makokha in Maharashtra, alright. But when it comes to India or on national level, we have National Security Act or NSA that was passed in 1980, and it is in recent concern about misuse in cases which have involved political activists as well as dissent. Alright, now over here when we talk about the democracies, so India is among few democracies which have permitted the preventive detention during peacetime as well. Now there are two perspectives which are there. The critics, they say that it is in violation of natural justice principles and due process of law, where there is potential for abuse against the political dissent. And the defenders, they have argued that it is a necessary tool for national security and public order, and it is just used as an emergency measure for extraordinary circumstances. Alright, now there are certain interlinkages. We have studied what the right to freedom is, Article 19, 20, 21, 21A and 22. The 5 articles which are the backbone of right to freedom in the fundamental rights. Now, when we talk about the interlinkages, Article 19 and Article 21 together, the freedom of, we have 6 freedoms and the right to life. So they interlink and they provide freedom with dignity as well as for the human rights protection. When it comes to Article 20 and 22, that is a safeguard against state excesses and also the arbitrary power that is there. Alright, in the case of where a person has been convicted or he has been detained or arrested. Then we have interconnected web of liberties and protections when it comes to the right to freedom, that is under the part 3 of the Constitution, and from procedure established by law to the due process of law, there had been procedural evolution of these rights. Alright, so that is how we have different linkages among Article 19 to 22, and Supreme Court has progressively interpreted these rights or articles as forming the integrated code of liberty, where each provision reinforces and expands the others through judicial creativity, and especially when we talk about Article 21, that is right to life and personal liberty. Now there are certain challenges to the freedom or the liberty that we are talking about right now. Like for example, there had been severe internet shutdowns. Alright, this had not been seen earlier, but right now there had been unprecedented restriction on digital freedom under Article 19, and over here when we talk about all over the globe, we lead in the internet shutdowns. Then there is preventive detention of the activists that is there. We have growing concern about the use of the various Preventive Detention Act, whether it is NSA or UAPA, against the civil society members as well. And recently we have seen its usage again. Alright, and also when it comes to press freedom and the fake news, there is a balancing that has to be done. The media freedom with the misinformation control and the defamation news, that has to be seen. Today, this is of very, very importance. Alright, and when it comes to the digital surveillance technologies, they challenge the privacy rights which had been guaranteed by the right to freedom, And again, this had to be seen how these will evolve. So these are the challenges that we are facing, or the contemporary issues that we are seeing, as well as there had been judicial trends and activism related to them. When we talk about the creativity, there had been innovative interpretation when it comes to right to freedom, and that has expanded the fundamental rights scope in India. Then we have PIL, or public interest litigation, as well, that have democratized the access to constitutional justice, and there is rights which have evolved. And therefore, when we talk about the Indian Constitution, it is a living constitution that has adapted itself to the various societal challenges that had been there. And these are certain landmark judgments which have been pronounced. We have PUCL versus Union of India in 1997, where right to privacy in telephone tapping was established, and also there were safeguards that were established for tapping of the mobile, or mobile surveillance, or the phone surveillance. Alright, there was Navtej Singh Johar case in 2018, where it has been, it has been pronounced that the consensual homosexual relations were decriminalized, and also that gave to freedom of sexual orientation under Article 21. Alright, now this is the comparative constitution analysis between USA, UK, as well as Indian Constitution. In USA, the First Amendment approached, and their absolute freedom of speech had been guaranteed with a very limited or minimum government interference, and there is strong protection against government censorship as well as marketplace of the ideas philosophy. Alright, then when it comes to the United Kingdom, there is parliamentary supremacy that has been adopted. Alright, their parliament has been, or it is supreme, and there is no codified constitution or entrenched Bill of Rights that had been given to the UK citizens. Alright, when it comes to India, there is balanced constitutional approach where we have freedom with certain reasonable restrictions which have been imposed in India. Now, what is the way forward? How we can extend the freedom in modern India? What should be the approach moving ahead? So there has to be institutional reform where we have to establish dedicated freedom commission like NHRC for monitoring the liberties. We have to have legal clarity where we can redefine the vague concept like public order, or as well as reasonable restriction with the objective criteria. Along with this, there have to be digital age protection where comprehensive legislation should be drafted for protecting the freedom and digital privacy rights, as well as democratic accountability where we have to strengthen the oversight mechanism for preventive detention as well as emergency powers that we have in India. Alright, so this is a summary that we have freedom, we have liberty, but it is balanced with the order, and there are certain reasonable restrictions which are there. We have the core foundations of Article 19 to 22 that forms the foundation for right to freedom in India. And we have a dynamic evolution that we have seen where the judicial activism has played a greater part in giving the freedom that were not granted, but they were inferred, and there were certain inferred rights which were given to the citizen of India through judicial activism as well, that have widened the scope of right to freedom in India. Alright, there is constitutional balance where the freedom is not absolute, and it has been, or it is there with the reasonable restrictions which are there in our constitution. Alright, so it has been said by George Washington that liberty, when it begins to take root, is a plant of rapid growth. Alright, now when it comes to or we near the end, I will ask you to brainstorm certain ideas. Like for example, is freedom shrinking in the age of digital surveillance and internet control? Alright, or can preventive detention truly coexist with democratic principles and rule of law? So these are the two questions that you have to brainstorm, and even if you can write the answer, that would be very much appreciable. Alright, so that would be all in today's session. I hope that you have a complete gist of right to freedom that had been granted by our constitution in part 3 of the constitution, that is fundamental rights. So that would be all. Thank you. Bye-bye. Take care. Jai Hind. But before going, let me ask you to like the session if you have liked the session, and also please share this with your friends who are preparing for the civil services, as well as do not forget to subscribe to our channel for more such interesting videos. Thank you. Bye-bye. Take care and Jai Hind. Thank you.